Welcome to today's Explainer. I am thrilled you're here with us today because we're looking at a landmark 2026 legal case that is fundamentally changing how we understand workplace rights. If you've ever thought that workplace harassment only applies to what a boss or a direct colleague does to you, well, this case is going to completely shatter that assumption. We are unpacking the truly shocking case of Eklom versus Marshall, a legal battle that delivered an astonishing twist in employment law and a massive financial payout.
Section 1. The $1,116K harassment payout. Okay, let's dive right into this, because to truly understand the impact of this case, we've got to start with the sheer scale of the financial resolution. This wasn't just a slap on the wrist. This was a loud, incredibly expensive message sent by the Federal Circuit and Family Court of Australia, a staggering $116,000. That is the total federal court payout awarded to a Queensland worker who was subjected to a horrific campaign of workplace sexual harassment. It's a massive figure that absolutely demands attention. But honestly, it's the origin of this payout that makes this case so incredibly fascinating for anyone who steps foot into a workplace.
Normally, when we look at workplace harassment cases, we're looking at a classic power dynamic, right? A toxic manager abusing a subordinate, or maybe a colleague on the exact same payroll who's crossing the line. But that is the massive twist here. The perpetrators who were ordered to pay this massive sum, they weren't even on the company's payroll. Literally, they were third parties, specifically an independent contractor and a regular customer. Wild, right?
Section 2. Hostility at the workplace.
To really grasp how this happened, we need to understand the human cost by looking at the harrowing ordeal endured by the victim, Samuel Eklom. Let's trace Samuel's journey for a second. In September 2023, he gets hired as a storage consultant at Storage King in Queensland. Over time, his role just balloons. He basically takes on the duties of a full site manager, juggling customer service, marketing, banking, maintenance, the whole shebang. He was already feeling totally overwhelmed. But then, in late 2024, the harassment begins, transforming his stressful job into an absolute nightmare. By February 2025, the abuse had taken such a toll that he was formally diagnosed with anxiety, stress, and a depressive disorder. And by July 2025, he was filing a lawsuit.
The abuse Samuel faced was relentless, sustained, and deeply, deeply hostile. It came from two men, Jacob Marshall, who actually started as a customer but became an independent cleaning contractor for the site, and Troy Mitchell, a high-volume regular customer. These two men targeted Samuel with explicit, homophobic, and sexualized comments. They'd call him the gay boy and the storage queen. When Samuel was just trying to do his job, crouching to clean a shed or plug in a phone, they would make vile remarks about him practicing for something. They joked about him getting assaulted or pounded from behind in the storage sheds. There was even unwanted physical contact, like shoving and bumping, which they'd just brush off as a joke. And it didn't even stop when Samuel clocked out. On one occasion, Samuel texted the customer, Mr. Mitchell, about a business matter outside of hours, only to receive the reply, "I'm at home, you poof." Just awful.
And this brilliantly illustrates exactly how the court viewed it. They saw this behavior as a twisted game for Marshall and Mitchell, where they just bounced off each other using Samuel as the punchline. The judge described the harassment as quite harrowing, creating an environment of severe isolation and degradation. And what's really important here is that the court stated Samuel's actual sexual orientation was entirely irrelevant to the case. The simple, undeniable fact was that he was harassed, and he suffered deeply because of it.
Section 3. The employer's failure.
Now, you might be asking yourself, where on earth was his employer in all of this? When you're being abused at work, your very first instinct is to turn to management for protection. While Samuel didn't just suffer in silence, he bravely gathered his courage and lodged a formal internal complaint with Storage King. And he didn't just bring allegations, he brought hard proof. He provided an audio recording he had secretly made that perfectly captured the severe, hostile environment these two men had created.
He would absolutely expect the employer to immediately step in, ban the abusive customer, fire the contractor, and protect their employee. But look at what actually happened. Management turned the issue right back onto Samuel. They completely ignored the harassment and instead accused him of breaching the Invasion of Privacy Act of 1971 by making that secret recording. The betrayal was just absolute. This forced Samuel onto personal leave to cope with his declining mental health. And while he was on that leave, suffering from a diagnosed depressive disorder caused by his workplace, Storage King moved ahead and fired him.
Section 4. Fair Work Act, Section 527D.
So Samuel initially sued his employer.
But when Storage King proved that neither harasser was technically an employee, Samuel had to find another way to hold his abusers accountable. And he did. Enter the legal hero of our story, Section 527D of the Fair Work Act 2009. This is a relatively new provision, and it is a real game changer. It explicitly prohibits sexual harassment in connection with work. And crucially, it completely closes that third-party loophole. Under this section, the specific legal identity or the employment status of the harasser is entirely immaterial.
Now, what's really interesting about this slide is how it answers a huge workplace question. If a customer, a client, a vendor, or an independent contractor harasses you while you're doing your job, who is liable? They are. The individual third party is held directly and personally liable for creating a hostile work environment.
To make this perfectly clear, the court used a brilliant everyday analogy. Imagine a waitress working in a restaurant. If a patron sitting at a table sexually harasses her, that waitress is legally protected under Section 527D. Why? Because the abuse occurred in connection with her being a worker in that business ecosystem. The patron can be sued directly, just like the customer and the contractor in Samuel's case.
Section 5. Protecting your workplace rights.
This brings us to the resolution of the Eklom case and what it really means for your own rights and protections in the workplace. Here's exactly how that massive $116,000 payout breaks down. The court ordered Marshall and Mitchell to pay Samuel $90,000 directly in compensation for the severe psychological harm they inflicted. The remaining $26,000, that was ordered as a civil pecuniary penalty split straight down the middle between the two men.
And here's the kicker. Those civil penalties are intentionally set high by the judge, even higher than what Samuel's own legal team originally requested. Why? Because Marshall and Mitchell showed absolutely zero remorse. No way, they just entirely ignored the litigation. They failed to show up for directions hearings or file any defense. So the judge determined that a strong penalty was absolutely necessary for strict deterrence, to carry a real sting so nobody else is minded to act in such an abhorrent way in the workplace.
So the crucial point is, enforcing these protections requires the right representation. The detailed insights for this explainer were sourced from the Australian Workplace Discrimination Representatives, or AWDR. According to their data, AWDR operates as Australia's leading non-lawyer workplace representation service. They have stood by workers for over 30 years, handling corporate-level disputes on a no-win, no-fee basis for things like sexual harassment and unfair dismissal claims.
The source material notes that their advisors provide specific 24/7 services and handle a range of strategic solutions beyond just sexual harassment. Their services cover unfair dismissal, toxic workplaces, general protection disputes, and constructive dismissal, basically navigating clients through the entire fair work system.
Which leaves us with this final, incredibly important thought. We've just seen that the Fair Work Act is powerful enough to reach past the boardroom, bypass the payroll, and hold a simple customer personally accountable for their toxic behavior. The protections are there, the representation is available. So if the law can hold a simple customer accountable for a toxic workplace, why are you still suffering in silence? You don't have to. Know your rights and don't be afraid to stand up for them. Thank you so much for joining me for this explainer, and I'll see you next time.